every case that I sign up, every client that I represent, ultimately it's the client's case. It's their injury, it's their slip and fall, it's their auto accident. In all my life practicing as an attorney, I have never taken a larger portion than the client. So the way contingency cases work in any personal injury case is the Florida bar mandates it, and attorneys get 33 1/3% if the case settles pre-suit and 40% if it settles after filing a lawsuit. A lot of times the biggest chunk of the settlement goes to the law firm. Starting off when I was a clerk and I was working at a law firm and I used to see those settlement statements, it just didn't sit well with me. I just didn't feel right that this was the client's case, this was their injury, this was their only avenue to become whole for what had happened. And now at the end of it, they're getting, what, 20 or 30% of the recovery? So what I've always done is, if at the end of it, it appears that 33% or that 40% ends up being the biggest portion of the pie, then I will reduce my fees so that in every single case that I have settled, the client has always had the largest portion of the pie. And I really do take pride in that, because I think that that's one way of making the case just about the client. I don't have to do that, and legally, and as it's mandated by the Florida bar, I can charge my 33% or my 40%, but I want to go to bed with a clear conscience. I want to go to bed knowing I worked hard and I gave the client what the client deserved, and that the client went home happy. Since this was their case, they got the biggest share of the pie.